All right, members, we've come to the appointed time and we've formed a quorum. So can we invite the administration team to join us?
Okay.
Okay. I don't think I need to introduce the government officers. We've held many meetings before. The 2014, or rather Insurance Companies Amendment Bill 2014, this is the 17th meeting of the Bills Committee. We formed a quorum and it's the appointed time. Let's get started. Agenda item 1. The legal advisor of the Bills Committee wrote to the administration on the 31st of March raising certain points relating to the legal matters and the drafting matters. The paper number is ZB bracket 1729/1415 bracket 01. I suggest that the committee, when we come to the relevant clauses, we will ask the legal advisor to explain her issues or points of concern, and then we will ask the administration to make a verbal response. And then afterwards, perhaps you can give us a reply in writing. Well, then that would be the easy approach, I believe. And we can discuss the relevant clauses in detail when we come to them. I think that would be more efficient. So today, we will not deal with this paper for the time being. We will follow up on what's been discussed last time, clause by clause scrutiny, where we start from clause 84, and that has to do with section 90 of the Insurance Companies Ordinance. And for the marked up copy, we've come to page Chinese version, paper number CB1 1833 131401, page 280. The government has also submitted a paper on the index for clause-by-clause examination, and the paper is CB1 369-1415-03, and that lists out the relevant clauses and how they relate to the policy areas to facilitate our scrutiny. So who to take us through the clause by clause, starting from section 90. Marked up copy, Chinese version, page 280. Let's start with section 90 of 280. And actually section 90 and section 91 are similar or are the same. It's just that they apply to different groups, licensed insurance agencies and then licensed insurance broker companies. So the sections 90 and 91 make certain requirements on the relevant companies and the responsible offices. On page 2881.8, a licensed insurance agency must establish and maintain proper controls and procedures, and they must use their best endeavors to ensure that the licensed technical representative agents comply with the relevant requirements. And they must ensure that their responsible officers have sufficient authority within the agency for carrying out their responsibilities, and they must also provide them with sufficient resources and support for carrying out such responsibilities. A responsible officer should also make sure that the agency has established and maintains proper controls and procedures and uses its best endeavors to secure observance with the controls and procedures established under paragraph A by the licensed technical representatives agents. Mr. Sin Chong Kai, I don't understand the wordings. Licensed insurance agencies, how do they differ from agents, and how do they differ from individual agents? Insurance agencies and agents, what is the difference between them? Who to take that question? Under our licensing scheme, well, it's similar to the existing scheme. We've got the companies and the individuals. The agencies refer to companies and partnerships, companies, and they also include sole proprietorship, those who own the companies themselves. Let me set an example. Banks are considered insurance agencies, and they will be getting the licensed insurance agencies license. Now, for individual agents, we call them tied agents in the sector. They are appointed directly, individuals appointed directly by the insurance agencies. Any further question? Mr. Sin. So does it mean that these sections 90 and 91 do not cover the agents themselves? We're just talking about the agencies and the broker companies, right? We are referring to licensed insurance agencies and licensed insurance broker companies, and they need to have a responsible officer. The responsible officer's conduct is regulated. We have the requirement that these intermediary companies must appoint a responsible officer. So in future, all the agents in the licensed insurance agencies, they still have to obtain an agent's license. Is that right? Yes. The employees of the insurance agents, when they engage in regulated activities, they must get this technical representative license. It's not called an agent's license, right? It's called a technical representative (agent) license. Any further questions? 91 is the same as 90. It's just that 91 covers insurance broker companies. Let's turn to page 283, section 92. Earlier on in our meetings, some members noted that the bill provides certain principles on conduct requirements for intermediaries. So the new section 92 empowers the authority to make rules requiring licensed insurance intermediaries to comply with the practices and standards. And they will be drawn up in the form of subsidiary legislation, taking reference from current practices in the trade. And bracket 2, under it, we've cited some scopes. For example, A, prohibit the use of any misleading or deceptive advertisement by a licensed insurance intermediary and impose conditions on the use of advertisements. And also E, require an intermediary to take specified steps to ensure that disclosure is made to its client of the coverage, terms and conditions, etc., in relation to the policy recommended to the client. The IIA sets must make certain rules, and they should consult the public and then present them for vetting by the electrical. So this will be in the form of subsidiary legislation. When we come to section 131, and that is on page 320 of the marked up copy, it states clearly that such a draft should be presented to the public for consultation and for scrutiny by the electrical. 92 says that the authority can prohibit the use of any misleading or deceptive advertisement. Well, it is easy to detect deceptive advertisement, but not so for misleading advertisement. We will only know whether an advertisement is misleading by the results or impact it creates. So what kind of guidelines should there be? to provide guidance to the sector on such advertisement. It has to do with the definition, and people may be caught inadvertently and easily. So are there any guidelines in the future on this aspect? This is my question. Misleading, how do you define it? Chairman, as I explained, these conduct requirements will be in the form of subsidiary legislation, and later on, we said that before such requirements are made, the authority must consult the public. So there is an opportunity for an exchange or dialogue with the sector. So the sector should be well aware of the requirements before they are made formal. And after this subsidiary legislation has been drawn up, the authority can further make guidelines to set out how one should comply with such a requirement. So we do have a mechanism to do that. Will there be any operational guidelines? Yes, we can issue guidelines. Well, that makes it clearer because there are so many insurance products on offer. The community will be very concerned about what we mean by misleading advertisements. People may be caught inadvertently, and the public may also be made available. Be made able to differentiate what is a misleading or not misleading advertisement. Well, there is a prohibition of the intermediary to make certain transactions. Can you repeat 208, page 284, 92H, 92H? Well, we haven't come to that yet. Well, we are just on page 283. You've moved faster than we did. All right, 284H. I can quickly explain. Under present practice, the Hong Kong Confederation of Insurance Brokers has issued guidelines on such scenarios. For example, without a signature, transaction cannot be effected. So there may be many scenarios falling under this point. There are, in fact, existing guidelines on the fact that there should be an analysis on the needs of the prospective policyholders. If the policy of the prospective policyholder doesn't want to have this analysis or assessment done, then he can indicate to the intermediary and he can waive that procedure. But this can only be done when the insured, the one being insured gives a clear indication, or else the intermediary will be breaking the law. Would that be a requirement on recording, say, the dialogue, or what? Commissioner, 92(2)(d), it says that an intermediary must take specified steps before providing information to its client. And actually, the entire 92 from A to L try to cover various scenarios in relation to the policies. With regard to the details as what you mentioned, whether there should be a recording or post-sale confirmation and so on, the further requirements to be drawn up under 92 will set out all these.
Now we don't need to set out the detailed requirements, but under 92(2), under 92, the examples cited by Mr. Sin can be set out. Let me ask some further questions. In the future, you have the power to regulate font size of prints. Is that right? In the guidelines or in the code, the intermediary is required to be honest in the sale of the products and not use misleading means. Under 22A, it sets out the specific steps to ensure that the various aspects of the policy is covered. And there is currently a trend. Can you speak closer to the microphone, Mr. Sin? Yes. I see that there is a trend to automate certain transactions. They are intermediaries. Say, for example, for travel insurance, you only have to do a few clicks on the internet and you complete a transaction. In the future, there may be insurance policies, say medical ones or whatever, whereby you can simply do everything on the internet. Does it mean that you still have the power to regulate these transactions? I want to ensure that you have the power to regulate these transactions in the future. In short, yes. 92 targets intermediaries. In the sale of insurance policies, they have to take specific steps, they have to follow guidelines. And when it comes to insurance companies, in relation to their conducts or steps, there may be guidelines promulgated. So the two together, coming back to Mr. Sin's point, online transactions, direct purchase, the steps or the requirements can be set out in detail. Let's continue. Next is 93 on page 283. Apart from the rules, 93 states that the authority may publish codes of conduct for giving guidance relating to practices and standards, and they are expected to be complied with in the carrying of regulated activities. And in bracket 5 and bracket 7 on page 285, they said that the code of conduct may serve as evidence in court, and if there is any dispute related to the code of the intermediaries, the court may make a decision on the code itself, and if there is non-compliance of the code, then the intermediaries may not be held against in civil or criminal proceedings. Mr. Chen Kim-po, in the future there may be a requirement for the intermediaries to disclose their commission, and when it comes to those 101 policies, that is insurance investment plans, then they are required to disclose their commission, and the current commission of insurance, they have introduced a lot of reforms. So I would like to hear from the Commissioner on this aspect. Is it the case that disclosure of commission is only related to investment insurance products? In 92F, it empowers the authority to set this out in the rules as to whether what products are covered when it comes to disclosure of commission. The authority will take into account the different products available in the market and also demand. There are many different types of insurance products. They are not all related to investment. Some are just taking out of coverage of protection, whereas some others may be savings plus insurance, and there are also some that are insurance plus investment. There are many different types, so we cannot use an across-the-board approach to cover all products. In the middle of last year, when it comes to insurance investment products, because there is a risk, since there is an element of investment in the product, it's set down that the calculation of commissions, method of disclosure are regulated, and there is a guideline promulgated, and the whole sector, the whole trade is using the same guideline. Currently, we have no plans to put in place the same requirement for other products. As I've said, that there are many different types of products. You cannot use an across-the-board approach on different products. And as to how it will develop in the future, I think we need to explore our way forward, taking into account the development of the trade and the sector, and whether there are specific problems that have arisen. First, we will cover disclosure of commission on insurance investment products. Well, on this kind of product, there has been a lot of discussions and meetings. We understand that this is a specific product that is different from general life insurance or other insurance products. So in the future, if you are going to introduce a change, you need to have an extensive consultation. Well, customers may only focus on commission and have forgotten about other aspects. And it's quite controversial why this only applies to a particular product. So in the future, you will have to have extensive consultation. I think the controversy doesn't just prop up today. In relation to 92, if the authority is to formulate any new rules, then the trade and the public will have to be consulted. There will be communication and thorough discussion before they are properly put in place. Let's continue if there are no other questions. Next is page 286, is part 12. It is in relation to the Insurance Appeals Tribunal. Well, anyone who is aggrieved by the decision of the insurance authority may lodge an appeal with the FS. As we've explained previously, part 12 covers the setting up of an insurance appeals tribunal. These provisions explain the establishment, composition, and power of the tribunal, and it also covers provisions of specific decisions made by the authority in the future, or specified decision. In Schedule 9, there are some specified decisions, and Schedule 10, you will find the procedures, provisions relating to procedures of the tribunal. If you would like, after we have explained these provisions in the main legislation, we can go straight to Schedules 9 and 10, so that we can have a discussion on the same subject. What do you think if we proceed in this way? Mr. Chen Kim-po, I would like to take this opportunity to say, before we go into the provisions of insurance appeals tribunal, I would like to ask Eddie, that is the Deputy Secretary. The trade asks that before the final decision is made in the disciplinary tribunal, an expert panel is to be consulted. If this is adopted, then it will give assurance to the trade, because it will be an alternative to a tribunal. The expert panel can comprise of people who are very familiar with the trade. The authority will only take into account their views, and if the view is not adopted, then should they explain why? Deputy Secretary, we've had a discussion previously. Before a disciplinary decision is made, the authority has already conducted a thorough discussion, and there will be an investigation report to state that the person involved is not a fit and proper person before a disciplinary proceeding is triggered. In 2012, in the consultation paper and in previous meetings, we have explained that there is a proposal to set up an expert panel comprising of mostly people from the trade. There are a lot of views from the trade saying that there is a great variety of products in the sector. Not one single person can know everything about all the products. And in order to uphold justice, before the authority makes a decision, it needs to consult this expert panel if necessary. Of course, for simple matters, say for example misleading, then we don't need to involve the experts. A decision will be made after consulting the expert panel. And if the authority doesn't have sufficient expertise or knowledge to make such a decision, it's only then that the expert panel is consulted. And as to whether it depends on whether the issue is a major issue, I don't think I can give you an across-the-board answer like that, because there may be misrepresentation that affects the interests of policyholders, and it doesn't involve expert knowledge. It's just a decision on facts of the case. I undertake that if necessary, and before the authority has sufficient information about the issue, they may need to consult the expert panel. And it doesn't depend simply on whether the issue is a major one. And if the authority does not take on board the view of the expert, and as to whether the authority is required to explain, I think we should leave it to the authority to work it out when they are formulating the rules.
And we also want to consult the trade on it, so that the trade's advice can be taken on board. I want to put it on record that it's an issue still unresolved, and we're still discussing it. It's just like the case of the oral hearing, cross-examination. You can also consider all these aspects just to make the disciplinary proceedings fair and just, and everybody can rest assured. For those who commit an offense or engage in misconduct, properly penalized, and those innocent are treated justly and fairly. So I think we haven't resolved this issue, and we should continue our discussion. We can put it on record here. The expert group, the DS, said that this is a consultative body. The authority will consult the expert panel. It's not the case that the expert panel will have the say, will call the shots. It will not act like the final court of appeal. According to what Mr. Chan Kim-po said, then revisions have to be made to the provisions. My understanding is the same as yours. The expert panel is really there to provide advice. The IAA is the body with the final say. Well, this we understand. No disagreement here. No overriding of their decision because they are independent, and there is no need to amend the provision. So, well, I just want to make this point clear. Mr. Sin Chung-kai, perhaps I've missed something. I don't get it. Where does the expert panel appear in all these provisions? Second, I know that the SFC has a process review committee. It is written in the law, and there is a review on the procedures and not the individuals. Since when you started allowing the trade to be consulted on such disciplinary procedures, if that is the case, you must be clear about where the firewall is and how do you go about doing it. Would you be disclosing all the details, the procedure, or just the details of all the case? If you are disclosing information to those in the trade, then if it relates to the people who are actually in the same company, then of course they will say no to further investigation. Will you be lacking justice when you do that by that approach? Let me provide some information. Expert panel is not provided in the bill or the ordinance. In 2010, when we first consulted the trade, in many discussions, the trade suggested or expressed their worry. They said that there are so many different types of products, and some products come with a very heavy technical elements. For example, insurance products involving airplanes, ships, and also IT risks. And so these can be very complicated, such kind of products. So for the OCI, should their staff be undertaking all the investigations? And when they make certain rulings or decisions, well, are they in a position to know about all the ins and outs of all these different products? The procedures involved, the details and so on, are they equipped to deal with all these details? So they said that they're worried. So we said we understand their concern. So that's why in the ordinance we set out the procedures for disciplinary proceedings. But then we agreed that in the manual of the OCI, an expert panel could be set up. And the expert panel comprises members from different from the fields of different insurance products. The intermediaries in these fields. Say if a certain case involves some uncommon products, not products like the insurance investment products, rather insurance policies are rather complicated. Well, then they should be referred to the expert panel, the relevant expert in the panel, and the names of the companies being investigated would not be disclosed. The expert can then provide advice on international practices in relation to that particular kind of insurance product. They would be giving us technical advice. So such advice can help OCI in our investigation and also our procedures in deciding on the penalties to be meted out. So the question is not whether the decisions are major decisions or not, because whether you call it major or not is something very subjective. So that's the background of establishing the expert panel, because the trade was telling us that do you know all the different types of products in the market? Well, we agree that we may not be well versed in some of the products which are more complicated. So that's why we established this expert panel, and if needed, we can consult the opinions from the expert panel. They are there to give us technical advice. So they will not be involved in the entire disciplinary procedures. So the expert panel is not included in the provisions, and we promise that once the authority has been established in its manual, we will be setting down the composition of the expert panel and when will we seek advice from them. So this is by way of background of the expert panel. Mr. Chen Kin-po. Well, let me try to say something more about the background. We've been talking about the government expert panel as what the commissioner said. Well, if there is something the authority doesn't understand, it can seek the views from the expert panel. It's whether to seek the advice. The decision lies with the authority. Now, we are talking about this Insurance Appeals Tribunal, IAT, and costs. Heavy costs may be involved. The sector hopes to have an appeals panel. It may comprise representatives from the Consumer Council, from the legal profession, and so on. But then the administration think this is not feasible. So our suggestion then is that we should have this expert panel to provide advice. Now, in the course of discussions, and some people said that we should consult. We should not be consulting the expert panel on everything, but rather the expert panel should be consulted only on complicated issues. So this is the expert panel. The concept is evolving, and this can be considered in the future. I'm just telling you that this issue has not been resolved yet. Now, according to what you proposed, then you said everything goes to the appeals tribunal, but then heavy costs may be involved and justice cannot be done because of this. So we hope that there is some room for maneuver there, and we should perhaps go down the route of the expert panel. So I just want to say this to make things clearer to everyone. Mr. Sen Chung Kai, according to the ordinance, well, I don't have any problem with the authority seeking expert opinions. But then in the course of investigation of certain cases, I don't see, say, the expert panel provided for here. SFC, there is a process review committee. That committee was written down actually in the law. And the committee there was not reviewing the cases. I've also sat on the ICAC's Operations Review Committee, and they actually look at the cases in detail, one by one, to decide or recommend on whether to take up prosecution. Well, if you want to go down that route, please make it clear in the ordinance that this will be done. If this is not written in the law, then I would assume that this doesn't exist. You are, based on your operation needs, seeking expert opinion. Well, I don't have any problem with that. You can take reference from the ICAC and the SFC. If you want to do something formally, please write that down in the law. Yes, agree. The expert panel, well, the idea is to have the panel members to provide advice on certain types of insurance products. They will not comment on the cases. And there is also the confidentiality rule. The names of the parties being investigated will not be disclosed. The experts will just provide advice on the details of the certain types of products, international practices related to these products. If there is no further problem, let's continue. Page 286, section 94. We have the definitions on affected persons and specified decisions. Specified decision means a decision that can be reviewed by the IAT. The specified decisions is listed in detail in Schedule 9. And after we are done with the principal sections here, then we can go to look at Schedule 9. And then we move on to Section 95 on page 287. Establishment of tribunal. It is 95(2) states that the tribunal has jurisdiction to review specified decisions in Schedule 9 and hear and determine a question or issue arising out of or in connection with a review. And it can review specified decisions too. 95(3), if the chief executive considers it appropriate to do so, the CE may establish additional tribunals for any reviews. If there is no further question, let's move on to Section 96. A moment, please, Mr. Sin Chung Kai. Chairman, there may be many tribunals at the same time, is that right? Section 96. The tribunal should consist of a chairperson and 2 other members, and it is to be presided over by the chairperson, who is to sit with the 2 other members. 96(2), a member of the tribunal, including the chairperson, may be paid the amount which is considered appropriate. Let's move on to page 288. Section 96. Remuneration. Mr. Chen Kim-po mentioned about an increase in costs. This is an appeal mechanism, this IAT. If there are any disputes arising from decisions of the authority, then the cases may be referred to the tribunal. Well, do you go by the payer pays principle, or how do you deal with the costs? The costs will be borne by the government. It will not be borne by the authority. Well, that makes it clearer. Because we said that there may be an increase in cost on the part of the affected person, then he may be deterred from going to the IAT. This is an independent IAT. It doesn't come under the portfolio of the IIA. It is independent of the IIA. Mr. Chen Kim-pong, he can rule on the costs, and the government will shoulder all the costs, we understand. The affected person may also be have to pay the certain costs. Well, the costs is not provided in Section 96. It only deals with the chairperson and the members being serving on the tribunal, and they get paid. Litigation costs. Yes, there is still a cost to be involved, but it's not being catered for in Section 96. It will be the affected person who is going to pay.
Let's continue. Page 288, Section 97, Schedule 10. It will set out in detail the appointment of members of the tribunal, the proceedings and sitting of the tribunal, and other matters. We will go to Schedule 10 afterwards. 98. It states that a person may, by notice in writing to the tribunal, apply to the tribunal for a review of a specified decision within a period ending 21 days after the notice informing the person of the decision has been served. Bracket 4 of 98 stipulates that the affected person may make an application, and the tribunal may, by order, extend the time. That is the 21 days. However, the tribunal will have to be satisfied that there is good cause and the affected person and the authority have been given a reasonable opportunity to be heard. 99. Its determination of review by tribunal. The tribunal may confirm, vary, or set aside a specified decision or replace the decision with another. The tribunal may also remit the matter to the authority with directions for the authority to reconsider. In bracket 4, it stipulates that the tribunal, before making a decision, must give the parties a reasonable opportunity to be heard. Bracket 5, it says that subject to section 102 bracket 3, that is in relation to contempt of the court. The standard of proof required to determine any question before the tribunal is to be the standard of proof applicable to civil proceedings in the court of law. Mr. Wong. 99. Bracket 2. If a specified decision is set aside, the tribunal may substitute for the decision another decision it considers appropriate. Can you make it simpler? I understand Mr. Wong's question. It is rather verbose. It says, well, yes, if the tribunal is to set aside a specified decision, and it may substitute a decision, and it may substitute another decision with its decision. And what if it says, we just change the order of the words in the Chinese version, that to make it simpler, to say that the tribunal may substitute the decision set aside with another decision it considers appropriate, because the two subjects are put one after another, so you won't be able to understand. The tribunal, if it wants to set aside a specified decision, should substitute the specified decision with another decision. So may I suggest that if the tribunal is to set aside a specified decision, may substitute it with another decision. I thank Mr. Wong for his view. The specified decision is a defined term. It refers to appealable decisions, so we cannot change or delete the term specified decision as you want. But there's already the word specified decision appearing once. If you say that you cannot change the two words specified decision, then you can say, well, may substitute another appropriate specified decision with it. Well, if you just say another appropriate decision, then who is to decide whether it's appropriate? Is for the tribunal to decide. So you cannot delete the words it considers appropriate. But the subject is already there. The tribunal. It's also the tribunal who decides whether to substitute the decision. Yes, Mr. Wong is right. The subject remains the same, which is tribunal. But the tribunal may substitute with what? It should be the decision it considers appropriate. It says, well, you just say that the tribunal will substitute the decision with another appropriate decision that it considers right. I thank Mr. Wong for his views. Well, from a perspective of the Chinese rendition, no, it's not that. You are the draftsman, but when it's drafted into Chinese, it's very verbose and it's a mouthful. I believe that when it comes to the Chinese rendition, well, both the Chinese version and the English version have the same effect. So I think with the sentence structure, whether it's to substitute A with B, and whether the object is to be replaced. Mr. Wang says that the object can simply be dispensed with. I have reservation to that. But that is in relation to the Chinese rendition. And 3, it says if the tribunal varies or substitute another decision for a specified decision, the decision is varied or the other decision substituting it for the specified decision. Can you explain it to me? In the Chinese rendition, there is the word or does not appear. Sorry, thank you. We've missed out the word or. We will submit an amendment. Because in the Chinese rendition, 2 verbs appear side by side. So that means you're not going to change bracket 2. Please continue. Next is the page 290, clause 1, section 100, bracket 1. The tribunal may, on its own initiative, on the application of a party to the review, receive or consider any material, and in C it says the tribunal may require a person to attend before it, and F it says that the tribunal may, in H, prohibit the publication or disclosure of material the tribunal received at any sitting. And in 102A to F, it says the person commits an offense if, without reasonable excuse, a person fails to comply with an order, notice of the tribunal. B, disrupts any sitting of the tribunal or misbehaves. C, without the permission of the tribunal, leaves. And D is to hinder the proceeding. E, threatened, insults any person. And F, threatened, insults the chairperson or any member of the tribunal. Page 292, bracket 3, stipulates the penalty level, which is $1 million or an imprisonment of 2 years. And on summary conviction, level 6 fine and imprisonment for 6 months. Section 101 stipulates that the information answer evidence provided is admissible in evidence against the person in criminal proceedings in a court. But it does not apply to criminal proceedings with an offense under Section 102A, that is, if the direction of the tribunal is not complied with to provide evidence. Part V of Crimes Ordinance is perjury. These are the exceptions to this section. Section 102, contempt dealt with by tribunal. The powers of the tribunal when it comes to contempt of court is the same as the court of first instance. Bracket 2. Without reasonable excuse, if a person engages in a conduct under Section 102A, B, C, D, E, or F, the tribunal may hold that person contempt of court. And bracket 4. In short, it says that no person will not be subject to double jeopardy because of contempt of court, that is, penalized by the tribunal court and at the same time prosecuted under a criminal offense. Please continue. Page 294, Section 103. Section 103 stipulates that an authorized institution, that is, banks, if someone is acting as the banker of financial advisor of the applicant for a review, then disclosure of information related to the affairs of its customers other than the applicant is not required. Please pause there. Well, we're talking about an applicant for a review. Who is an applicant for a review? That is the applicant who applies for a review. That is the aggrieved person. You mean the appellant? Yes. No other questions? Section 104. It empowers the tribunal to make orders to award costs. The tribunal may, by an order, decide who the cost should go to. And High Court Order 62 applies to the award of costs and taxation of costs awarded by the tribunal. In short, the tribunal has the power to award costs and tax costs. When doing so, it should give reference to Order 62 of the Rules of the High Court. The cost order, they are those that are usually adopted in a civil proceeding. Who is to take this question? Sorry, speakers of mic. It says that if the court is to exercise discretion to tax costs, it should take into the following factors. That is, the parties and their conduct. Say, for example, whether they have put forward reasonable arguments, whether they have deliberately delayed the proceedings. The idea of costs is to discourage parties to delay the proceedings. And if delaying tactics are adopted, and as a result costs for the other party increase, then the person engaging in such conduct or strategies or tactics will have to bear the cost. And these factors for consideration are set out under Order 62 of the Rules of the High Court. I see that the appellant, that is the applicant for a review, may retain a senior counsel or a barrister. Is 115. So does it mean that is in a civil proceeding, you would consider the seniority or the level of the counsel? Order 62 does not say that the type of legal representative is to be taken into consideration. Order 62 mainly deals with a conduct, that is, conducts that will delay the proceedings or cause unreasonable reasons put forward.
Of course, when the other party unnecessarily uses a certain legal representative and that adds costs to the other party, Well, in awarding the costs, that can be taken as a factor. Please continue. I would like to share my views from the sector. Many people are worried that if we don't set up the expert panel, then the only recourse that they can take is the tribunal, and they are worried about the litigation costs, say, and they hope that there should be a cap, say, $50,000. If the government has difficulties in drawing that up, can you share with us the difficulties? Thank you, Chairman. I must reiterate our principle in assessing or awarding the costs. We don't want the two sides to the litigation trying to delay the procedures out of no good reason. And in the appeal mechanism, there is no requirement that a legal representative be hired. Of course, either party has the right to do so. The chairman of the tribunal has discretion to award costs. This is a discretionary power, and the chairman can also consider the economic situation of the appellant and maybe exempt him from shouldering the costs. And if he has come forward with reasonable justifications and he's not done anything to procrastinate, to delay the process, and then he may not be asked to shoulder the costs. We don't agree to putting a cap to the costs because it will undermine the spirit behind the award of costs, because we don't want to encourage people to delay the process and present on sound arguments. And actually, under the existing mechanism, there is indeed already an appeal mechanism, and in Section 17 of the procedures, it is also stated that has regulations with regard to the magistrates' courts. Now, under the existing mechanism, if the insurance agents are not happy with certain decisions, they can lodge an appeal with the magistrates' courts. And it is stated that the magistrates' courts can ask the party who loses the case to shoulder other costs, and they should be taken reference from the relevant practices and orders in the High Court. So under the existing mechanism, there is no cap on the costs. Please continue. Sorry, the speaker is not coming through. Please pass the mic to the consultant, the legal advisor. In the letter, we said that we propose in the proposed Section 104 and that's similar to Section 2060 bracket 2 in Cap 571. It has talks about litigation costs as well. And in Cap 571, this clause, which is similar to Section 104, and it says clearly that in awarding the costs, that would be paid from the general revenue of the government. But in the proposed new section, that is not specified. So is there any particular reason why no such specification is made in the bill? DS? We would compare this clause with the Cap 571, which is the Securities and Futures Ordinance. We would make some comparison and we'll come back with a reply to the legal advisor. What about the legislative intent? Would it be the same as that for the SF ordinance? Cap 104 on the costs. And actually, in many appeal tribunals, laws and similar provisions are there. We'll go back and take a look. Mr. Langsing. 109, stay of execution of determination of tribunal. Should there be a maximum period for the stay? Well, we haven't come to section 109 yet. Okay, let's go back to 105 on page 295. It says that the tribunal must notify the parties of the review to the review its determination and reasons, and if it is a closed door hearing, the tribunal can make an order prohibiting the publication or disclosure of its determination. 106. An order must be recorded in writing and be signed by the chairperson of the tribunal. 107. Orders of tribunal may be registered in court of first instance, and this order so registered is to be regarded as an order of the CFI, section 108. And application for stay of execution of specified decisions. 108 bracket 2 states that a person who applies for a review may at any time apply to the tribunal for a stay of execution of the specified decision. Sorry, the speaker's not coming through. You are on 109. Well, 108 is related to 109, and they both deal with stay of execution. Should we be specifying a maximum period for the stay of execution? Perhaps we should first look at section 109 before we deal with your concerns. 109. That has to do with the determinations of tribunal, and the party to review can apply for stay of execution. So my main question is, how long should the stay of execution be? If this is a stay of execution for a reasonable period, then that's acceptable. But if it is too long, the period is too long, then it will affect people, because that has to do with the liability of the parties involved. Is there a limit on the timing of the, well, that is listed in Schedule 10. We haven't come to that yet. The chairman of the tribunal can make certain decisions on the stay of execution. The tribunal chairman must be a person who can be appointed as a judge in the High Court. This is his qualification. This should be his qualification. So that would be a period, a time limit. It will be up to the chairman of the tribunal to make the relevant requirement. That would be a time limit, right? Yes. All right. Page 297, section 110. Appeal to Court of Appeal. If a party to review is dissatisfied with the determination of the review, the party may appeal to the Court of Appeal against the determination on a question of law, a question of fact, or a question of mixed law and fact. Bracket 2. No appeal may be made unless leave to appeal has been granted by the Court of Appeal. Sorry, the speaker's not coming through. Sorry, the speaker's not coming through. Sorry, the speaker's not coming through. So you can say any party instead of that party. Sorry. We repeat the words that party because up above said that if a party to a review is dissatisfied. So you said any party and you didn't specify which party. But here it says that party, so it means a specific party. It's not any one party. So it's one of the parties. So why do you say that party? Well, there should be a party who is satisfied, or even both parties may feel dissatisfied. Why do you use the word that party? because that word has the implication that it refers to a specific party. Whether it's a subject to any sentence, as what Mr. Wang rightly pointed out. So if a party to a review is dissatisfied, that is a precondition, and then what he can do is in the second phrase, and then for the second phrase we need also to have a subject. This is a complete sentence, and we don't need the word the party. I agree with Mr. Wang. Now, if I reword it or rephrase it, if the first phrase, the subject in the first phrase is a party to a review, then we can do away with the subject in the second phrase. Well, let's look at the English rendition. The first phrase has to do with the condition, and the second phrase has to do with what act he can pursue. So I'm not trying to be picky here. The English and the Chinese grammatical rules are very different. Well, unless you tell me that the English should be taking precedence over Chinese, but well, the Chinese version is also very important. We cannot just literally translate the English version. This is a problem we're facing in drafting. The Chinese version of the law is very often incomprehensible, while the English version is okay. I agree that we should not just have a literal translation of the English version into the Chinese version. This is exactly what you're doing here. As I explained, there are two ways of writing it. Well, in the first phrase, should you do it as construct it as a conditional phrase, or do you want to write it as a main phrase? Well, I must emphasize that I will not be very adamant on it, but I think there is a problem with the way it is written now. Even if you still stick to this writing of yours, then the meaning would not be undermined. But I think it would be better if you can change it, revise it a bit. When you talk about that party, would that be people be misunderstanding the meaning of this phrase? Well, it may be the case that both parties are dissatisfied. And you should not just be pinpointing one particular party, because the word that party refers to a specific party. I notice that in what you said, there is reference that there may be the case that both parties are dissatisfied. But if you say just that party, well, we usually take that to mean just one party is dissatisfied. Would that be the implication? Well, I have to clarify, because that question should not arise. In a litigation, there may be the case that both parties are dissatisfied, and both of them can lodge an appeal. When the law operates, it should be targeting somebody. And I would be saying here that if a party to review is satisfied, and then the party A is unhappy, say, then he can make an appeal. Now, if party P is unhappy, dissatisfied, then party B can also lodge an appeal. So this is the way it is commonly worded. And in law drafting, we should try to avoid too encompassing or all-encompassing cases. We try to put it in a singular, the noun in a singular form. In the review, if a party is dissatisfied, he can lodge an appeal.
So the term "the party serves a purpose" is narrowed down to the aggrieved party. And it's only that party that may make an application. Mr. Porter, I'm afraid that this is not the only place where we see this problem. And we always see this problem in the Chinese and the English rendition. It's very verbose, and I'm afraid if we are to change it, it will be a lot of work. And I think the DOJ will have to coordinate. Well, we always say it's Chinglish, but I think this one is English. We understand it, but it's a mouthful. It's not just what you said. There is a difference with the English rendition. I have a question anyway. Well, when it comes to an appeal, apart from grounds of legal points, on facts, and on both, is there a fourth scenario? Because it says here it can be facts, it can be on facts, it can be on legal points, it can be on both legal points and facts. Can it be? Should it be listed out so clearly? Can you maybe change the way it's phrased to cover the three? Ms. Wong? Thank you. I agree with Mr. Zhe. A, B, and C covers all the issues that may be dealt with by the tribunal. But we think this is clearer. C, it says legal and mixed law and fact. We think that this will make it clearer when it sets out the powers of the Court of Appeal to deal with what cases. Adding these words will set out very clearly the power of the Court of Appeal. Well, if there is a restriction on the scope of appellable issues, then it will be set out. Otherwise, it won't. Is there any reason why you have to set it out in such a convoluted way? Well, in High Court proceedings, the Court of Appeal usually deals with a point of law. It doesn't usually deal with facts. So we make it clear that the power of the Court of Appeal is not like what is not like the usual impression of the public, so that the powers will not be mixed up. If you would like the Court of Appeal to have to have the power to deal with a wider scope, that is to deal with the question of fact as well, then do you have a policy? Is it your policy to get the Court of Appeal to deal with matters that is different from its usual practice? Because if the Court of Appeal deals with facts, then it will be a retrial practically. When the decision of the tribunal goes to the goes to the Court of Appeal, I think it's similar to Cap 115 and Section 71 and Section 229 of the SFO. When the decision of the tribunal goes to the Court of Appeal, the Court of Appeal enjoys the same power. So you are fully aware that is a policy for the Court of Appeal to review the entire case. And you think that you should adopt a consistent approach this time. Thank you for the question. Well, this is the instruction we received when it comes to the policy. That is to adopt the same approach with the other two tribunals I mentioned. 111. It stipulates that the Court of Appeal may allow the appeal, dismiss the appeal, vary or set aside determination, or remit the matter to the tribunal or to the authority. Page 299, Section 112 stipulates that when it comes to an appeal to the Court of Appeal, it doesn't operate as a stay of execution, and if there is a need to have a stay of execution, an application may be made to the Court of Appeal. Section 113. Well, other than Section 110 and yes, Mr. Sin. So you need to apply for leave before you can go ahead with the appeal, and then you will apply for a stay. I think there are two separate matters. Who is to answer this question? Apply for leave to appeal. For 110(2), you have to get a leave to appeal. So you can only apply for a stay of execution after you have obtained the leave to appeal. Mr. Sin's right. In 110(2), it says that the Court of Appeal should grant leave to appeal before it proceeds. So before I apply for leave to appeal, then can I apply for a stay of execution? To whom do you make the application? Because the Court of Appeal has yet to hear the case. 112(2) clearly states that if an appeal is lodged, the Court of Appeal may order a stay of execution. So you need to get leave to appeal first. You need to apply for leave to appeal first. Section 113. Well, apart from Section 110 and Section 50 of the High Court Ordinance, which states which is related to appeals in relation to contempt of court. Apart from these two sections, determination of the tribunal is final and is not subject to appeal. Section 114. Yes? So 113. Well, I don't take the court to the Court of Appeal. I will take it straight to the CFA. Is it the case? I don't really understand your question. Can you repeat it, please? Section 113 says that subject to Section 110. 110 states that the case will go to Court of Appeal. It says that if that is not the case, then the decision of the tribunal is final. Does it mean that I can choose to go to CFA? Perhaps I will defer to the DOJ. We've mentioned this in our papers to the to the Bills Committee. Section 113 doesn't state that parties cannot apply to the CFA for an appeal. It just says that other than the appeal under Section 50 of the High Court Ordinance and Section 110, there are no other avenues for an appeal. It doesn't mean that the person cannot take the case to the CFA after a determination has been given by the Court of Appeal. I understand. Then my next question is, after the tribunal, I skip the Court of Appeal and go straight to CFA. Can I do that? I think you're talking about something completely different. If you don't follow the procedure, will the CFA hear your case? Chairman, you're right. Under the Court of Final Appeal Ordinance, you will need an appeal from the CFA. and it's the decision of the CFAO and the decision of the CFA. You can't take the case straight to the CFA. My understanding is that you simply can't take the case to the CFA straight away. Well, some case can go from the High Court to the CFA. Of course, that is the case. Mr. Porter, can you explain? Can a case go straight from the district court to the CFA? Yes, you can leapfrog. It will skip certain procedures and to expedite the dealing of the case. So you can leapfrog then. Any other questions? No? Mr. Zhe, I have some questions to ask. Just now it was said that when it comes to an appeal, in theory, if there is a major point of law, the matter can go to the CFA with leave. But Section 113, does it cast doubt on this possibility? You said that is the policy intent. But which provision does it say in this bill that it doesn't stop anyone to take the case to the CFA with leave when it comes to major point of law? Under the common law, you cannot stop a person from taking the case to the CFA. For Section 113, actually, you will find similar wordings, including the anti-terrorism financing, Section 74, and SFO, Section 231. There are similar wordings, and under the common law, there are cases clearly states that a person has the right to go to the CFA after his case has been heard. His rights will not be detracted. I know that common law overrides statute law. And even if it's so stated in the statute law, then the right to go to the CFA will not be undermined in any way. But I would still like to be referred to the relevant provision. Yes, I'll do that. Please continue. 114 on page 299. Time when specified decisions take effect. The specified decision takes effect before the expiry of the period of 21 days. If an affected person notifies the authority that it will not apply for a review, and if within the period of 21 days the person does not apply for a review, or if the person applies for a review of the decision within the period of 21 days specified, if the decision is confirmed by the tribunal, and if the decision is varied, or if the application is withdrawn. Please continue. Page 300, Section 115. Chief Justice of the CFA is empowered to make rules, to provide for the award of costs, to provide for matters relating to registration of an order of the tribunal in the CFI, to regulate the procedure for the hearing of appeals. Please continue. If there are no questions, we'll have completed the provisions related to the tribunal in the main legislation. We can go straight to Schedule 9 and 10. They are relevant provisions. Schedule 9 is on page 406 on the marked up copy.
In this new Schedule 9, Part 1 and Part 2 specify the specified decisions made in relation to insurers and insurance intermediaries. Those affected by such decisions can lodge an appeal with the tribunal. With regard to specified decisions in relation to insurers, they are set out in Part 1, items 1 to 3, authorization of insurers, and items 4 to 14, the controlling officers, the appointment of the officers, and items 15 to 22 have to do with the imposition of a requirement on an authorized insurer. Item 23 has to do with exercise of power to take disciplinary action against an insurer. Items 24 and 26 to 26 are related to the refusal to approve the appointment of a person as the authorized representative of Lloyd's. These are specified decisions, and appeals can be made against these decisions to the tribunal. Any question? If not, then let's go to Part 2, page 411. These have to do with specified decisions related to insurers, intermediaries. Items 1 to 12 have to do with granting an insurance agency license, and item 13 is exercise of power to take disciplinary action, and items 14 to 17 have to do with license matters and transitional arrangements in relation to disciplinary actions. Schedule 10 now, running from page 415, appointment of members and proceedings of tribunal. Page 416, section 2, or rather sections 2 to 4 specify the composition of the tribunal. The chief executive must appoint the members of the tribunal depending on the chief executive decision. The number will be decided. The panel member must not be a public officer or a member of the authority. Subsection 3 says the chairman should be appointed by the chief executive, and the chairperson must be a former Justice of Appeal of the Court of Appeal, a former judge or a former deputy judge of the Court of First Instance, or must be eligible for appointment as a judge of the High Court under Section 9 of the High Court Ordinance. No question. Please continue. Schedule 4, Section 4. Schedule 10, Section 4. For determining a review, the Secretary of CED, on the recommendation of the chairperson, must appoint 2 panel members as ordinary members in relation to the review. Section 5 specifies that the hearings should be held in open, and closed hearings may be held in private for certain reasons. All the sittings must be attended by the chairman and 2 ordinary members and should be chaired by the chairperson. If decisions have to be voted upon by the panel members. Please continue. Page 420. Mr. Sin, you have a question. You talk about resignation. If a member resigns, a new member is going to be recruited. Is there any requirement? Please speak closer to the mic. You are so far away from the mic. We can't hear you. Sorry. There have been provisions providing for the resignation of members of the tribunal. if the hearing hasn't started, it's all right then for him to resign. But once the sitting has started, what will happen if a member resigns? DS? Chairman, if the chairman resigns, he must be, the resignation must be accepted by the CE because he's appointed by the CE. And if that happens, another person should be appointed, another judge should be appointed to attend the sitting. Now, if it is an ordinary member, and the members, a new member should be appointed by the Secretary for CED. And if in the middle of the sitting, the ordinary member resigns, the chairperson then will make recommendations to the Secretary of CED to appoint a person to attend the sitting. Well, does it mean the hearing has to start all over again? Well, if that happens, the member resigns in the middle of the sitting. Well, later on, I will be speaking that except for certain circumstances where the chairperson has the right to make a decision on his own, most of the decisions have to be made by the chairperson together with two members. So if another member resigns in the middle of the sitting, the composition of the tribunal has to be reconstituted. So the hearing has to start all over again. Yes. Mr. Sin, are you clear then? Legal advisor. Please. The administration has made a clarification just now. We have been doing this clause by clause scrutiny on the IAT. But for that part, the requirement here has not been clearly set down. Say in the middle of a setting of a case, and then the tribunal has to be reconstituted. And this is something very important, and I think it should be categorically specified. In the provisions, there is no such requirement here. So, would that be provided in other provisions? We would discuss with the DOJ on whether we should make amendments, come up with new sections to provide for that scenario. I agree with the legal advisor. Of course, we have to take note that the chairman is empowered to determine certain procedures. We have to study with the DOJ as to whether the scenario that we mentioned should be covered by that provision. But the chairperson may also resign himself, and if the chairperson has a right to determine certain procedures, he can do so on matters related to the two ordinary members beneath him. I think you should note that down and study it further. Mr. Sin. I think you may be copying the provisions from the SFO here. Well, 10 years ago when we scrutinized the SF bill, we didn't pay attention to that. Since the legal advisor has brought us to the attention of this, then we should tend to it. Well, if there is an omission in the SF ordinance, it doesn't mean that we should not be doing anything here. So perhaps we should also remind somebody to add that in the SFO as well. I would like to ask a question on 3.7. It says that the chief executive may, by notice in writing, remove the chairperson from office if the chairperson has engaged in misconduct. Well, conflict of interest, neglect of duty, well, it's difficult to define those terms, and misconduct is even more difficult to find. What do you mean by misconduct? Well, drink driving, is that considered as misconduct? So I have queries on this point. DS. Misconduct, how do you define it? Mr. Sin, can you repeat your question? Yes, I can. In removing the chairperson and the members from office, page 418, subsection 7, it says that the chief executive may, by notice in writing, remove the chairperson from office, B, on the grounds of incapacity. Bankruptcy. Well, it's very clear. Neglect of duty, conflict of interest. Well, these terms, meaning are relatively clear. But for misconduct, well, I think it's a legal term. If in the middle of a sitting, the chief executive removed the chairperson, then it's very problematic. Well, that kind of scenario may be rare, of course, but I would like to find out what do you mean by misconduct. We don't give a definition of misconduct as far as the tribunal is concerned. We just use our common understanding when we come to the term misconduct. When we scrutinized bills, we might have missed it. I think you might be copying from the SFO. I think there is a problem with the word misconduct. Neglect of duty in a court. Say perhaps you were absent in a court proceeding, then that's problematic. Neglect of duty, that's obvious. But in a court, well, misconduct can be easily seen. But outside the court, what do you mean by misconduct? Drink driving, do you consider that as misconduct? Well, you may be jailed for drink driving. Mr. Paul Chair perhaps can help out here. Mr. Sin talked about 7 and subsection 8 also says that if a review has been commenced by the tribunal but not completed before the expiry of the chairperson's term of office, the chief executive may authorize the chairperson to continue to act as the chairperson for completing the review. Now, can subsection 8 be applied to the scenario happening in subsection 7? Well, for subsection 8, we're talking about the review not completed before the expiry of the chairperson's term of office. So that is very different from the chief executive removing him in subsection 7. So the subsection 8 will not be of help. Well, you're talking about the 3 years tenure here, right? Yes. Mr. Paul, Chair, can you enlighten us on this? Misconduct in other laws. I think this word appears all the time in other pieces of legislation. Misconduct? Or is this happening? Chairman? Well, misconduct takes on different meanings in different laws and different sectors. And this is a catch-all phrase. Well, sometimes if a photograph is being taken and you take out an advertisement in an illegal sector, then that's considered misconduct and you risk your license being revoked. I understand that this misconduct, the word is rather, covers a broad scope. And by drafting a bill, the draftsmen would like to be as flexible as possible and would try to catch the culprits as much as possible. And for the victims, of course, the misconduct can, the meaning of misconduct can be very broad. You haven't answered my question yet.
In other provisions, can we find information about misconduct? I actually have answered your question, and the answer is no, because every profession is very different. It's a very wide catch-all section. I believe the FSTB is just copying from other provisions that have been endorsed. So I understand that if the chairman has lost the capacity, has been incapacitated, bankrupt, I understand. Conflict of interest, yes. Neglect of duty, yes. But misconduct, if they want to remove you, they can use this very vague reason to remove you. 421, Section 6. Preliminary conferences. It says that the chairman may, on his own initiative or on an application direct, that a conference be held for any or more of the purposes set out in subsection 3. That is, the chairman, after considering the material submitted, considers it appropriate to hold a conference and the parties agree. The purposes of a preliminary conference can be found in bracket 3. They are A. To enable the parties to prepare for the conduct of the review, B. To assist the tribunal to determine issues for the purpose of the review, and C. To generally secure the just, expeditious, and economical conduct of the review. Section 7 on page 422 stipulates that with the consent of the parties, the chairman may make a consent order setting out the conditions or the terms. Mr. Tse, I would like to backtrack a bit. Has the administration considered under what circumstances a case or a hearing is conducted in chamber? If you take reference from the Anti-Terrorism Financing Ordinance or the SFO, if it's related to sensitive information or international arrangement, you may have conduct in-chamber hearings. And in the area of insurance, what are the issues that you consider sensitive that would require an in-chamber hearing? Well, it says that when it comes to appeal hearings, they have to be open. When the chairman, for reasons of public interest, or when the applicant makes an application to have an in-chamber hearing, then that may be a hearing in chamber. And if the chairman thinks there is a need to have a hearing in chamber, well, I've already mentioned is public interest. You only read out the provision at the request of the chairman or public interest. What I was asking was under what circumstance do you think there is a need to have hearings in chambers when you copy the provisions from the SFO and the Anti-Terrorism Financing Ordinance? Or is this just a simple copy and paste exercise? It's not that we foresee the situation. It's because we consider whether there is a need to have an hearing in chambers for the reason of public interest. Is it the case that the administration would like to give itself some leeway so that if the occasion arises, then you can conduct a hearing in chamber? May I say that the insurance sector is a part of our financial system. Let me give you an example. Say if the issues involved or the facts of the case may affect the stability of the system, then there may be a need to have a hearing in chamber or in camera. We allow a hearing in chamber under our policy, but it has to be supported by grounds. Say, for example, whether it will cause instability. I think it depends on the case and how the chairman sees it. The spirit of the law is that in general they are open hearings or public hearings, but under special circumstance there may be a possibility of a hearing in chambers. We want to give ourselves the flexibility. Mr. Sin? Can you read the provision again? I can't see the word public interest. Sorry. I might have, it might be a slip of tongue. The chairman may exercise discretion to have the hearing in chamber. That is just to ensure justice. But never mind. Is it the case that it is too wide because public interest is still narrower in scope than discretion? Deputy Secretary, it's difficult to say whether it is wide or not. The policy intent allows the chairperson to exercise discretion to choose to have a hearing in chamber. In Schedule 9, we have already covered this. Well, if an insurance company would like to get a license to operate a business in Hong Kong, if the authority refuses to issue a license, it may be a reason for appeal. Will there be reasons to require a hearing in chamber? In general, it will be a public hearing. The authority should only make a specified decision when there is sufficient evidence. Mr. Sin. Let me give you an example. Let's refer to 408. 408. Object to a person being proposed to become a controller of an authorized insurance. Say, for example, the authority authorized a certain person to be something or to do something, and if it's hearing in chamber, then I won't know what interests it serves. Sorry, it says in the provision that the affected person of the decision of the authority, say for example, is an insurance company, it would like to appoint a controller, and it needs a confirmation from the authority. The affected person will be the insurer. If it's aggrieved, then it may lodge an appeal. You mentioned 408. The objector is the authority. It objects a person being proposed to become a controller. So the decision is a rejection to appoint a certain person as a controller. Then the controller is the affected person, and that affected person may lodge an appeal. It's not anyone, because the decision is a decision of the authority. There is a provision that states that all hearings are to be public. I think it's 5. 5, bracket 5. Yes. Bracket 5 and bracket 6, how do you reconcile them? Well, if it's in private, then it's in private. Of course, the chairman will think that it is in the interest of justice. So it's not just the chairman who requests a hearing in private. Someone can make an application under 6. So that means an affected person may make an application. Yes. There is a problem here. If in a hearing there is this mechanism, right, that you have the right to apply to have a hearing in private, then we need a barrister. Mr. Leung? Oh, well, I am not sitting here in the capacity of a barrister, just a legislator. I see that in Schedule 10, it says the chairman must be a former judge of the court of must be a former judge or former deputy judge of a court of first instance, must be a former justice of appeal of the court of appeal, or must be eligible for appointment as a judge of the high court. And it seems that they have borrowed procedures from the high court. I can't find it now. If you say that, well, since the judges of the High Court have discretions, because it doesn't specify in the High Court ordinance what hearings are to be held in public and what in chambers. So there is no hard and fast rule, and there is some flexibility. Say, I don't know, will there be cases involving commercial secrets? Say this chairman based on what will the chairman make a decision? Can it be spelled out? And I think a more fundamental question is why it's done by way of a schedule. I don't really understand. That is, when it comes to the appointment and the hearing procedures, why are they in the form of a schedule? In the future, when we need to amend this schedule, it will be a positive hearing, but it's not clearly specified.
Mr. Leung, just a moment. I think it's time's up 6:30. Do we agree to extend the meeting for 15 minutes to deal with this issue and resolve it, and then we are done with today's meeting? Let's look at subsection 5 and subsection 6. Every sitting of the tribunal must be held in public. Our policy intent is that the hearing should be held in public. And in subsection 6, it says that, however, if the tribunal, or on its own initiative or on the application of any of the parties to the review, determines that in the interest of justice of a sitting, a part of the sitting must be held in private. So only under that circumstance will the sitting be held in private. And it's not the case that the entire sitting must be held in private. It can be the case that part of it is. So if you look at subsections 5 and 6 together, you will see that ordinarily speaking, the tribunal sittings must be held in public. Now, why do it by way of a schedule? We've taken reference from other laws. This is a tribunal set up under the insurance company's ordinance, and we've discussed with the DOJ, and we believe that it should be set out in the schedule. This is a new establishment, and operationally, if we need to make changes, then if it is put in the schedule, then it can be easier done more easily, and we can rethink or reconsider how the drafting can be improved. Commissioner, Section 136 talks about amendment to Schedule 10. So, but that doesn't cover Schedule 10. So, any changes to Schedule 10 must be done in relation together with the primary legislation. Well, what do you mean by justice? Well, in Chinese, it's 公正. Do you mean 公義 or 公正 in Chinese? Well, it's just a slip of tongue. In Chinese, it's 秉行公正. Well, the 秉行公正 is different from 秉行公義. And then the interest of justice in English is also different. When you talk about justice, usually refers to a procedure. But then if you talk about 公義 in Chinese, it covers a wider scope. I mean, is this your policy intent? He said he admitted to a slip of tongue. Next meeting. Date of next meeting, the 20th of April, a Monday, 10:45 a.m. Another meeting, the 7th of May, a Thursday, 8:30 a.m. We'll continue with our discussion next time.